Thank you for joining us for this episode of Season 3 of Comply on the Fly with M3 and Karen B. Comply on the Fly is your trusted weekly resource for reliable insight and quick answers to common employee benefits compliance questions. Please note this podcast and the contents herein do not constitute legal advice. Seek the advice of counsel for any employee benefits compliance-related guidance or strategy.
Hello, everyone. I'm Karen B., and the Comply on the Fly topic for today is Section 125 plans, or cafeteria plans, and the written plan document requirement. Federal law mandates that all employers who sponsor a Section 125 cafeteria plan must have a written plan document in place. According to the rules put forth by the Internal Revenue Service, or IRS, the document must include all of the rules included in Section 125 and be adopted prior to the first day of the plan year. By definition, an employer sponsors a Section 125 plan if the employer offers participants the opportunity to pay for benefits on a pre-tax basis. This includes health plan premiums, flexible spending arrangements, and dependent care programs. The cafeteria plan document that is required, or Section 125 plan document, must include the following information: a description of the available benefits, participation rules, election procedures, manner of contributions, maximum amount of contributions, the plan year, if purchase or sale of paid time off is offered, the ordering rules for using elective versus non-elective paid time off, or PTO. If the plan includes an FSA component, the plan's provision for complying with any additional requirements relative to the FSA. If the plan includes a grace period or carryover, the plan's provisions complying with the IRS requirements as they pertain to grace periods or carryovers, a uniform applicability statement, and of course, a list of qualifying events that would allow a Section 125 election to be changed mid-year. The written plan document technically must be formally adopted by the employer and its management structure. It is important to note that even if an employer has a premium-only plan, or what's referred to as a POP, without any other benefits under the cafeteria plan like medical FSA or childcare, the employer is still required to adopt a written plan document. If an employer does not have a written Section 125 or cafeteria plan document, or the document does not comply with the requirements, the plan is not considered a Section 125 or cafeteria plan. The result could mean that contributions could lose their pre-tax status and/or the plan itself could be disqualified. It is important to make this plan document available to employees just as you would with any other plan documents. Many times you may need to have a conversation about qualifying events, and it is important that you can point employees to this document for more information. Please note that the Section 125 plan itself is not an ERISA plan, but the medical FSA is usually considered a plan covered by ERISA, and therefore should be included in any ERISA SPD documentation. And that is your Comply on the Fly topic for today. Thanks for tuning in.
For more compliance insights from Karen B., please visit m3ins.com.